The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
The floodgates have swung open and voices from the King of Pop's past may come back to haunt him. Hello, I'm James Curtis and welcome to E's exclusive coverage of the Michael Jackson trial. The courthouse took on a Hollywood aura when comedian George Lopez and his wife Ann arrived in style to testify about their relationship with the accuser's family. Now, early reports wrongly claimed that Jackson was late again. In fact, he didn't have to be in court during hearings that were held outside of the presence of the jury, and in fact, when he was supposed to be there, he showed up in plenty of time. But all that star power, folks, was overpowered by four little numbers: 1108. Affectionately known as 1108, it's an evidence code section that will undoubtedly change the course of this trial and probably the fate of Michael Jackson during these proceedings. Judge Rodney Melville heard arguments on whether prosecutors can introduce evidence of so-called prior bad acts. District Attorney Tom Sneddon got right to the point. Here's what happened according to the courtroom transcripts.
First, we're asking the court's permission to allow us to have one prior child victim testify to 3 separate incidents of molestation by the defendant. The molestations are very similar in nature. They involve the genitalia of the kid, of the child, and they involve instances where 2 instances outside the clothing of the child on a prolonged basis, and a 3rd incident where the hand was thrust up inside the pants of the child, onto the skin of the child. We're seeking to admit no less than 5 third-party witnesses of inappropriate molestations and touchings by the defendant as to 4 separate children. Again, the conduct is similar in nature. Some of it is kissing, hugging, and other parts of it involve, again, insertion of the defendant's hand into the genitalia of the particular children involved. I think it's noteworthy to bring to the court's attention, as I will also cover in certain parts of my other presentation to the court. All of these children are basically between the ages of 10 and 13 at the time that the offenses occurred or were observed by third parties. We have an additional incident, an additional witness who will testify to incidents involving the defendant with children, 4 other children, observing the defendant in bed with 4 other children, and on 3 of those occasions, observing the child and the defendant in bed, and that the child and the defendant's underpants were lying next to the bed.
Well, next, District Attorney Tom Sneddon lays out Michael Jackson's alleged M.O.
We have a 6th incident that involves the same child that has already been observed by at least 2 other witnesses that are on our list to be called as being that observed acts of molestation by the defendant. And this witness observed the defendant licking the head of a child in the identical manner to that described by Star, as will be described by Janet. We think this is particularly probative in light of the defendant's contention filed by papers in this court, that this is an example of Janet delusional state that she saw this, when in fact we have another witness who saw this very conduct occur by the defendant as to another child about the same age as Gavin. Lastly, we have 2 witnesses that will testify to the fact that the defendant encouraged children to call him daddy, children other than the children in this case, and that he talked about with the mother of one of the children how it was important that the mother think of him and the children and them as being all one big family, and they were like family together. We submit to the court that in this case, of course, the pattern in the similarities, that the victims are similar in age, the manner in which the victims were cultivated is similar, and the crimes are similar. And under these doctrines, I think, are all the more reason why this evidence should be admissible.
All right, I want you all to get ready for probably one of the most impassioned discussions that we're ever going to have during this trial. Ricky, let me start with you. Let's lay out the background because we're going to get rolling on this and we may never get back to it. The background here has to do with a couple of little pesky code sections. One's called 1101 and the other one's called 1108. And that's the evidence code section of the state of California. 1108 is relatively new. 1101 is that standard thing that we all learned in law school that says if you have evidence of motive, opportunity, intent, preparation, essentially some sort of pattern, then you can introduce that. But traditionally, you can't introduce stuff that says they're just a bad person.
Right, and I think that the way we've all understood it as we've grown through law school into being lawyers, and I think the public understands it, is usually the robbery example. A bank robber who was on trial for bank robbery yesterday, if he committed a bank robbery 5 years ago or 4 years ago, you don't introduce those old bank robberies because obviously the jury considers that he did this one because he did that one. What happened here, which has been called the Michael Jackson exception to the evidence code, is that in sexual assault cases, particularly involving children, that these kinds of prior bad acts are going to come in, and in essence, there's a presumption that they're coming in.
Exactly. And Howard, here one of the big distinctions is we're not talking about prior convictions. We're simply talking about prior alleged conduct. And the reason why alleged is important here, it's not just a technical term, is because none of this stuff has ever been proven in court.
That's correct. It's interesting. Tom Sneddon actually used the word crimes that are similar. What Tom Sneddon forgot is a crime is something that is judicially approved. Jurors find people guilty of crimes, not district attorneys throwing out words. And what's happened here, they're going to allow somebody to come in and tell stories without any finding of truth.
Now, one exception, and let's lay this out for everybody, Sean, that is the DA wanted 7 different incidents, alleged incidents, again, none of which have ever been arose to the level of convictions, none ever proven up in court.
Not even arrests.
Not even arrests, but 2 of the incidents were kept out. 5 will come in, but of those 5, we only have 1 alleged victim. Everybody else coming in are people who it didn't happen to. It was told to them.
And that is really what I think is so stunning. I think we've all expected that this evidence was going to come in, but we also expected that the victims themselves, the alleged victims, were going to testify. I don't know if we've seen a case since this law has been passed where the victims themselves are not coming in, but third-party witnesses are going to testify to these events.
Yeah,
it's unheard of.
It is preposterous, and as I said before, unfortunately, the train is on the track, and it's not just bad for Michael Jackson.
Right.
It is an issue that all people that get involved in the criminal justice system have to be concerned about. I can come in and say, I saw something, give my interpretation of what it is, basically bad person, as Ricky said, bad guy, bad lady, and the evidence comes in, the jury gets to consider it.
We're going to keep going with this discussion. This is really a watershed moment in this trial, and despite our collective assessment, my somewhat reservation, their all-out opposition to this ruling, it's noteworthy that no less than 5 California Supreme Court decisions have upheld this statute, with a whole slew of lower court decisions. Well, you've heard our take on this evidence. Here's Tom Mesereau's take, and he pulls no punches in his analysis of the situation.
The evidence they're trying to introduce is evidence of a highly inflammatory and emotional nature. There's no question about that. But I think the court also has to look at the substantive part of the evidence that they want to introduce, because from what we can see in the cases that we've looked at, every time they've introduced 1108 evidence in a case like this, they have had a separate alleged victim describe something similar. Nowhere can we find they are just willy-nilly bringing in third-party witnesses to say they saw something without bringing the alleged victim in. Yet that is exactly what 99% of the evidence they plan to bring in is. Who are their main witnesses? Their main witnesses sued Mr. Jackson in the mid-90s. And for the first time, Mr. Jackson decided, I'm tired of settling these stupid cases. I'm actually going to defend this one. It resulted in the longest civil trial in the history of this courthouse. And the court, I'm sure, knows a lot more about that case than I do. At numerous times during that 6-month trial, the trial judge made findings that the plaintiffs were lying, not being candid, changing their stories, even leaving the bench on a couple of occasions. And when the dust settled, the jury returned a verdict for Mr. Jackson, awarded Mr. Jackson damages because the plaintiffs had stole from him. The judge then awarded not only costs, but legal fees. And in the end, Mr. Jackson obtained a judgment for over $1 million against these lying plaintiffs. They want the court to allow these lying plaintiffs to come in now again and try and testify to improper acts when there is no alleged victim they intend to call. That's just plain wrong.
Ricky Kleeman, speaking of just plain wrong, Is it the judge's ruling that folks should take issue with, or is it simply the way this law is written?
Well, I think it's the way the law is written. I don't think the judge had absolutely any choice here. The way the law is written, these prior bad acts come in when it involves sexual conduct, particularly sexual molestation. In fact, you could have had a prior acquittal, and it could still come in under this law.
I just disagree 100%. The judge had every opportunity not to allow this in. That's what 352 of the Evidence Code provides.
Explain what that is.
Probative value versus the prejudicial effect. For example, these lying defendants, as Mr. Mesereau references, is a case I am very, very familiar with. To allow them to come in after juries made the finding they did, that their accusations were not true, and to allow them to testify before this jury is pathetic and an abuse of judicial discretion.
And not just that, but the judge is going to let in the settlement evidence. And Mesereau makes a good point here, which is that Michael Jackson settled these cases not necessarily because he was guilty, but because he wanted to just move on with his life. And we all know there are many compelling reasons why people choose to settle a case or plead guilty to something, and not because they did it.
And we've all advised people to do that in order to get rid of a case.
And the important distinction here, unlike, because I do disagree as a former prosecutor, to a certain extent about prior pleas, but settlements in the civil arena, that seems like it's a different animal. When we return, the suspense builds as we await the all-important ruling from the judge himself, his own words, his own mouth. And later, George Lopez and the missing $300. Remember that one? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Defense attorney Tom Mesereau insists that money motivated this alleged, supposed, maybe victims from the past, and having paid that money does not mean, according to the defense, that Michael Jackson did anything wrong. Well, here's what happened according to the courtroom transcripts.
In summary, this is what happened. Parents had been divorced in 1986. The father had given up custody of the child. When these alleged events happened, the father jumped on the bandwagon and wanted to become a multi-millionaire, and he fueled litigation. And all of a sudden, you had the parents suing Mr. Jackson. You had the mother's new husband then decided to sue Mr. Jackson for allegedly interfering with his business. He had an auto company, and he claimed that the publicity had interfered with his business. He wanted millions. After the settlement, the father then filed a new lawsuit against Mr. Jackson, wanting $30 million more. That was litigated, and he lost. You have all sorts of collateral litigation, and eventually Mr. filed papers in Superior Court seeking legal emancipation from his parents. Where is the justice in this case of allowing parents to come in who've collected lots of money because Mr. Jackson wanted to get this case behind him and pursue his music career? And indeed, all kinds of advisors were telling him to do that.
Next, Mesereau is not impressed by the state's case.
Then we come to Macaulay Culkin, who has repeatedly made statements that he's a friend of Mr. Jackson and has never been molested. But they want to bring in evidence that he was molested. And they want to bring in witnesses who also were part of the gang that sued Mr. Jackson and lost, with findings that they had lied, and with enormous damages awarded against them. The fourth alleged victim is Jason. Jason and his mother were interviewed by the sheriffs, and a deposition of the mother was taken. Money was paid to settle that case, again because Mr. Jackson didn't want the press, didn't want his family going through it, and wanted to pursue his music career. There never was a criminal prosecution, even though the alleged victim was interviewed by the Los Angeles District Attorney and the Santa Barbara District Attorney together. And after their interview with Jason, which was so wishy-washy about what happened, they never decided to pursue a criminal case because there wasn't one. We have that taped interview. The mother, in a civil deposition in the litigation, began by saying she saw something and ended by saying she saw nothing. And indeed, stories were sold to tabloids and money was paid to settle. He appears to be the only alleged victim they want to bring in. The bulk of their 1108 evidence, Your Honor, are third parties with axes to grind who have tried to get money and gotten money and had the problems I just identified. Where is the fairness in allowing that kind of testimony, that kind of evidence, when their underlying case looks so weak and so problematic?
All right, defense counsel collectively referred to. I'm going to put my prosecution hat back on because it was hard to don it just a moment ago. But don't all these arguments by defense attorney Tom Mesereau go to what we classically know as weight versus admissibility? That is, it's not an issue of whether or not it should come in. It's what importance this jury is going to assign to it, no?
No.
Okay.
And I say yes.
All right, go.
Let's go to Howard.
Well, no, the importance the jury is going to attach to it, if it's presented, the presumption is there's some truth to it.
Yeah.
In fact, you have incidents that were investigated and the district attorney's office did not prosecute it. And you can believe if Tom Sneddon could have prosecuted these cases 10 or 12 years ago, he would have. He didn't because he didn't believe he could prove them. Despite the fact that he couldn't prove them, he wants these people to come in and testify before this jury.
With any of that, Ricky?
Well, I can't disagree with it in terms of what the theory is, but I can jump sides for the sake of argument to the prosecution. The prosecution has a tool. The tool is that the legislature enacted 1108, that the judge can rule and the prosecution will benefit because of this. No prosecutor is going to sit back and say, I guess I won't try to introduce this evidence. Of course they will, and I think Mr. Sneddon thinks he's bulletproof because those cases have gone up to the Supreme Court of the state of California, and they've been affirmed.
All right,
so
Sean,
he's going to do it.
Let me get your input on the other side, Sean, so I can get to this.
Just,
piece.
should I?
Yeah,
Oh, wait.
just hold it. Yeah, we're done. Okay. It's an action-packed situation around here. Now, District Attorney Tom Sneddon goes on the attack, and Sean will attack me later during the break, and it gets a little personal here.
I will only say this, and this will be the only thing I will say. Gavin sat on that witness stand for almost 3 days. The first day he was on there for almost 40 minutes. And Mr. Mesereau was as abusive, was as mean-spirited, and was as obnoxious, frankly, as you could be to a child witness in a case. He spent the next 2.5 days with binder after binder after binder, coming up here and asking things. That kid didn't have a piece of paper in front of him, not a single piece of paper. And I think it was a remarkable job that that child did. He was never once tripped up about the fundamental fact that the defendant in this case molested him. Somehow we're to be penalized because victims don't want to show up. They don't want to go through what Gavin went through. It takes a lot of courage to do what that young lad did. And I don't think, as Urquiza said in his testimony, most children don't ever in their entire life disclose. And it's not a far stretch to believe that the reason they don't disclose is for the very reasons that we've seen in this courtroom. That no family and no child wants to go through what you have to go through to be vindicated when you're molested by an adult, by somebody you trust, and somebody you loved at one point in time, as somebody you cared for. They put it behind themselves, and they move on with their lives. Their lives aren't always the same, but that's what they do.
Well, both sides were holding their breath in anticipation of Judge Rodney Melville's ruling, and fortunately, he didn't make them wait very long.
The arguments presented by both sides here were very good arguments. And they're arguments bringing up the law and the factors that I've been working with trying to reach a decision in this matter, which is of such great importance in this case for both sides. The arguments didn't really bring up new material, but they definitely emphasize the concerns I've had. You know, the weighing of the case as I've heard it, the remoteness of the alleged charges that would come under 1108. But ultimately, the decision I've reached, and which I'll now announce, is that I'm going to permit the testimony with regard to the sexual offenses and the alleged pattern of grooming activities.
There you have it. Sean, take it away.
Well, I agree with Ricky that the judge clearly has the legal authority to make this ruling. As you said, the Supreme Court has upheld this law. But I think the danger in this case, and in all criminal cases, is what happens really to an innocent defendant. I think if the defendant is guilty, a child molester, and past acts of child molestation come in, then everybody agrees with that. But the danger is if you've got someone innocent, Michael Jackson is innocent, the jury's going to attach unbelievable weight to these other alleged victims, and that's going to make the difference.
Doesn't the prosecution, Sean, run the risk at this point? So much is going to come in under this ruling. 5 additional incidents. If Tom Sneddon makes, if the defense attorney Mesereau makes any credible assault on that information, on the credibility of those witnesses, doesn't the prosecution's house of cards fall apart?
I don't really think so. As I said before, I think in a child molestation case, the beyond a reasonable doubt standard is lowered. Jurors don't want to make a mistake in a child molestation case. I don't think that they hold the state to that burden of proof. And just hearing about past allegations, I think it makes it that much easier for this jury to
Where
convict.
there is smoke, there is fire. Will that be the jury's reaction somehow? Well, we'll have to wait and see. When we return, George Lopez like you've never seen him before, folks. Stay with us.
An arrest warrant for Mr. Jackson has been issued on multiple counts of child molestation. The bail amount on the warrant has been set at $3 million.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Comedian George Lopez is used to being in the spotlight, but here in this courtroom, it's got to be one tough audience. The sitcom star had met the accuser's brother, the accuser's sister, while helping out at that comedy camp for underprivileged children that you've heard a little bit about in prior testimony. Now, under questioning by Assistant District Attorney Ron Zonin, Lopez describes how he came to know the mother of the accuser. He talks about the dad a little bit later on. Here's what the jurors heard according to the courtroom transcripts.
Did you get to meet their mother?
I did.
What was her name?
Her name is Janet.
All right. Over the same period of time, did you see her?
You know, I only saw Janet during the period of time that we spent at the Laugh Factory.
Was she there every time?
She was there.
With the kids?
Every time.
Do you know how they got there?
They took the bus.
Did that impress you in some way?
Absolutely. I mean, you know, anybody that rides the bus in Los Angeles is a hero to me.
Do you know from how far away they were coming?
They came from East Los Angeles.
To Hollywood, is that correct?
To Hollywood.
During the period of time that you knew the was in association with the Laugh Factory, did Janet ever ask you for any assistance in any way?
No.
Did she ever ask you for money in any way?
No.
This went on for a period of how many months to your knowledge?
Well, the whole time that I've known the family, it was probably 8 months.
At some point in time, did you become aware of the fact that one of the children became ill, seriously ill?
Yes.
And how did that come about?
I got a phone call from Janet on my cell phone. And, you know, as any mother would be completely distraught and was asking for help. And I went to the hospital as soon as I found out that Gavin was as sick as he was.
The call then came from Janet?
Yes.
And did you then go to the hospital?
I did.
And what did you find when you got there?
Well, I found Gavin in dire condition. I mean, he was really just clinging to life. And that's when I met David. I had never seen him before until I showed up at the hospital.
You didn't meet him during the time, maybe I'm wrong about this, during the time that the kids were at the camp, at the comedy camp, that period of a couple months?
Right.
You know that disclaimer we tell you about the man or the young man playing the accuser in our reenactments doesn't look like the actual accuser? Well, disregard that about this one for George Lopez. He does look a little bit like him. Anyway, the David referred to by George Lopez is the father of the accuser. The prosecution sees David, the dad, as a very important figure in this case.
During your dealings with the father at that point, during the number of months that Gavin was ill, did he ever ask you for assistance in any way?
Yes.
And when do you think was the first time, if you know?
Probably the first time was maybe February or March of 2000, approximately. Yeah, around there.
But this was after Gavin became ill already.
Yes.
And in what way did he ask for assistance?
Well, you know, he made it known that he was, you know, strapped for cash. And at that point, I would help him with whatever I had on me. You know, I'd give him, you know, $40, $50 if I had it. Whatever I had, you know.
Did David talk with you about doing a fundraiser on his behalf, or rather, his child's behalf?
Yes.
And what was the nature of that discussion? What is it that he was asking you to do?
He was asking me to take care of a fundraiser for Gavin, which I was more than happy to do. But then it became apparent to me that it wasn't about Gavin anymore. I was about how Gavin was and how he was feeling. I wasn't about money for Gavin. And it seemed to me at that time that David was more interested in the money than he was about his own son.
All right. Was David working at the time, to your knowledge?
To my knowledge, I don't think he was working.
Did he ever express to you any concerns about insurance, medical insurance?
I was always led to believe that they had no insurance whatsoever.
All right. And that was from David?
Yes, sir.
You never had a conversation with Janet about that subject?
Never.
She never asked you for money?
Never did.
Ricky Kleeman, doesn't the defense or hasn't the defense committed the classic error in your theory of your case? I thought it happened in OJ to the extent of, well, let me just outline it generally. Basically, it's painting too broad or too narrow of a target, depending on what side you're on. In the OJ Simpson case, I thought marrying themselves to a timeline was a mistake. Why commit yourself to things that you don't have to prove?
Well,
Doesn't the defense do the same thing here?
Here, what happened, which I think was a mistake in retrospect, is that Tom Mesereau really went after the fact that the mother was the grifter. The mother was the person who put all of this together. The mother was the person who got money from people like George Lopez. George Lopez appears in this case very early on.
Yeah.
So the prosecution calls him in their own case, and it all turns out to be, no, Mom, yay, Dad, and Dad is the bad guy. Mesereau needed to say it was the family, not the mother.
Well, you know what I think the prosecution is trying to do here really is show that David is a bad guy, because later on, David is going to say the mom got the kids to lie. And so what they're trying to do is show the jurors that David cannot be trusted when he says that.
It's really the dad, not the mom. Will it spill over on the entirety of the victim's family or just hurt the defense? Next, a poorly written sitcom or just a bad reality show. The real reason why George Lopez is in this witness box, folks. Lopez describes what happened after taking the kids, that is the accuser's brother and sister, on a shopping spree.
Now, when you finally get back home and David left, what did you notice in the house?
Well, I took them home, and I came back. And we had this room that really a lot of people have. It's very popular with Mexicans. We have a room that no one's allowed to sit in, and everything stays. Everything stays put. And it was our house, and even I wasn't allowed in that room. So on the mantle, there's nothing on the fireplace mantle except this brown and black wallet. So as I walk in the house, your eyes immediately go to the mantle. It's the first thing you see. So I see this wallet, and I pick it up, and it's not mine. And I open it up, and it has an ID, Gavin's ID. And I look, and there's a $50 bill in it, one $50 bill. So I go to the kitchen, where my wife is, and I say, Ann, Gavin left his wallet. So we call Gavin, tell him that he left his wallet. They say to drop it off at the Laugh Factory. We end up sending it in the mail so that we can get rid of it. And then sometime later, I understand through Jamie Masada at the Laugh Factory that David told Jamie Masada, who owns the Laugh Factory, that I had taken $300 out of Gavin's wallet.
Okay, Janet never accused you of taking money from her son's wallet. Is that correct?
No, that's correct.
Did you ever have a conversation with Janet about the wallet?
Never.
About the wallet, did you ever have another conversation with David?
I never did. Oh, after the wallet? After the wallet, I had the exchange on May 5th.
Now, when you had the exchange on May 5th, did you already know, had you already had the conversation with Mr. Masada about the wallet?
My wife did.
All right. Did you know about it at the time?
I did.
Of the conversation? Was that one of the reasons that you no longer wished to be associated with them?
You know, that might have put me over the top.
And on cross-examination, defense attorney Thomas Mesro wants to know why this actor can't seem to remember his lines.
Do you remember signing a declaration under penalty of perjury in this case on February 16th, 2005?
Yeah.
Do you remember testifying under penalty, not testifying, do you remember swearing under penalty of perjury the following? I never provided money to the or any of them.
Yes.
Well, that wasn't true, was it?
Well, at that time, I couldn't recall.
So on February 16th, you couldn't recall under penalty of perjury if you gave any money to any of the correct?
That's right.
But when you met with the prosecutor on Friday, you suddenly recalled that you gave David money on a periodic basis, right?
Right.
You gave him, what, no more than 40 or 50 bucks at a time, correct?
Right.
And you thought the total was less than $400, right?
That's correct.
Howard Weitzman, on this cross-examination, this is about the only place where Tom Mesro can go on this witness, isn't it?
This witness is no questions, Your Honor, and you let the witness go. He provides really nothing for the defense, in my opinion. Ricky's analysis in the segment before was 100% correct. George Lopez is up there because the prosecution wants to impeach the father who's going to testify for the defense.
But isn't there an internal inconsistency, anybody, with respect to, he says, the mom never asked me for help, but then he specifically says she called me from the hospital asking for any help she could. Isn't that enough?
Right. Well, I think that that's enough if you wanted to just do that segment. The difficulty you have here is Tom Mesro is opened with the fact that George Lopez is their guy, is the defense guy, and he's going to show you that this is a family that lies and defrauds and grifts. And what you have here is, in essence, it's like the defense impeaching their own witness, the defense attacking this witness that they need.
Well, we're going to see how that plays out in the final analysis. Could the prosecution actually be winning now? When we return, Ann Lopez and the father of the accused engaged in somewhat of a showdown that has to be bleeped, folks, for television. It's not just us. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. The saga of the found wallet, the missing money, it all continues as Ann Lopez, that's the comedian George Lopez's wife, is on the stand. Here's what she told the jurors according to the courtroom transcripts.
When you got home after the visit to the shopping mall and Gavin and David left, did you notice anything in the house?
I did not. I just went straight to the kitchen. I started to prepare dinner. And when George came home, I heard him say, "Hey, what's this?" And I walked into the living room, which we barely used, and there was a wallet on the mantle. And I said, "Well, open it and find out what it is." And it was, you know, a Velcro, normal little Velcro wallet, and it was Gavin's school ID. And there was a crisp $50 bill in it. And we just thought that it was rather strange that there would be a $50 bill in a 10-year-old child's wallet.
What did you do with the wallet?
I told George, well, I'm going to call and just send it back to them.
And did you do that?
Yes.
Okay. How did you send it back?
I think Federal Express. Just sent it back so that they would get it the very next day because I figured he needed the money.
And the $50 bill was, of course, still in the wallet at the time you sent it back.
Yes. Huh?
At some point in time, did you hear from anybody with regards to an issue of money missing from the wallet?
The way we found out about that was about a month after we stopped having any contact with David. I called Jamie Masada for a completely different reason. I just needed a business number. And you know, we were talking. He gave me the number I needed and he said, "Listen, by the way, I want you to know that. Remember that wallet?" And I said, "Yes." And he said, "Well, you know, David said that the wallet was empty when it was returned." And I said, "Jamie, it had $50 in it." And he's like, "Well, he says there was $300 in it and that it was empty when it was returned." And I was like, "Jamie, do you really think we would steal $300 from a child that we've been trying to help?" And he said, "No, I know you didn't do it, but I gave him the $300 just to get him off my back." And I offered to reimburse Jamie $300 and he said, "No, absolutely not. Don't worry about it." I was like, "Are you sure?" And he was like, "Yeah, just don't worry about it."
Next, Ann Lopez says she smells a rat, so what do? You set a trap, and she set one for the accuser's father.
Did you finally decide to have a conversation with him that dealt specifically with where the money was going to go?
Well, what I did was I decided to test him. And I told George what I was going to do. I said, you know, I just started feeling very uneasy. And I said, you know, there's something strange here. I want to test him to make sure that his intentions are honorable. And so what I did was I called him up on the phone and I said, well, David, I just wanted to let you know the fundraiser is going to be at such and such time, such and such date, and I needed to start getting your bills. You know, I need to get the name of your landlord, I need to get your credit card bills, your gas bills, so we can start paying them. And he became, you know, a little like, what do you mean? Aren't I just going to get the cash? And I said, no, we can like prepay your rent for 6 months, we can pay your bills. I said, no, that's not how it works. And he said, well, some people that I owe money to, I just owe them money. And I said, give me their names so we can pay them. And he got very agitated. And I said, well, listen, this is, you know, the radio station is involved, and that's the way it has to be handled because they need to have documentation. And then he got very angry at me.
This is a little odd behavior, but, well, let me just put it out there. Howard, go ahead.
I don't know what you mean by odd behavior. I don't understand why this testimony is coming in at this point in the case or what its purpose is. If it's
well, its purpose is to show that the dad, exactly.
Wait, Daddy hasn't testified yet. Maybe when Daddy testifies and we want the jury not to believe his testimony, we can introduce evidence that he's a liar or a cheat or a scoundrel.
But doesn't it go
you can't
to deal
introduce it in the
with
case
the
in chief.
proposition that the defense put out there that it's all mom, bad mom, bad mom?
That's an argument. Where's the evidence?
No, it's not just an argument, Sean. It's cross-examination.
I mean,
and it came in through cross-examination as well.
You're just saying it's not in the right order of things.
It's not in the right order.
But at some point it may have come in.
Maybe.
Maybe.
Wait,
I mean, it is a bit bizarre. We have to say, what does it have to do with anything beyond the fact that dad's the grifter, not the mom, and what Mesereau has always said is it's mom who's the grifter. The prosecution says, hey, wait, it's dad, and they weren't even together when these alleged acts of molestation took place. So we can't say this is a plot hatched by the family.
What if Dad never testifies?
Right.
So you're impeaching somebody who didn't show up in court, but didn't now the defense open that proverbial door that we've talked about time and time again, saying that, look, it's mom, it's mom, it's mom, it's mom. Doesn't the prosecution get to, before they call mom, to put this evidence on to rebut that line of cross-examination?
James, that's not the way it works.
Why not? Come on.
Well, you know what they'd say. We're doing it, right? We'll get the lawyer's word. De bene. We're going to tie it up later. Eventually it would have come in.
It's not the way it works, so says Judge Weitzman. As testimony continues, the accuser's father allegedly goes ballistic, and Ann Lopez happens to be in the line of fire.
All right. You say he got angry at you. How did he manifest that anger? What did he do? What did he say?
He cursed at me.
What did he say? I know this is a little embarrassing, but what did he say?
He called me a and that's when I hung up the phone.
Was he angry while he was saying this?
Oh, he was irate. His whole demeanor changed.
And loud?
Oh, yeah. It was like he frightened me. I was shaking when I hung up the phone.
Did he ever present like that to you before, prior to that date?
No.
Either in person or on the telephone?
No.
All right. Despite whether or not this stuff should have come in at this time, and certainly legally you have a good argument, I'm going to give that to you, Howard, but let's pull back and take another aspect of this, perhaps the psychosocial aspect of it. Herein, let's go back to our good friend Louise Palanker and Fritz Coleman. They just give money with no accountability, no checks and balances whatsoever, and that may be laudable, but isn't the idea of kind of knowing where the money goes, even though this is not true what Ann Lopez says, isn't that kind of what you might want to do when you're giving people thousands of dollars?
Absolutely, but of course she's not necessarily doing this because she really wants to know where the money goes. She's doing this to put David, the father, in his place and say, look, you want money from me? Well, we're going to control the spending of the money. But ultimately, it all goes one way or the other. Either the family's a family of grifters and therefore Michael Jackson is a mark, or on the other side of it, you had a sick child whose father may have been out to steal the money.
But again, I think the defense is going to call David. to say that the mother put these kids up to lying in the past civil case, and so what the prosecution is doing now is showing that David cannot be trusted. He's a bad guy in all of these instances. So
well,
when that happens, we distrust
We're going to have a custody battle as well as 5 sexual assault cases.
Yes,
Right,
so these are
right.
5 sexual assault cases with only one victim of a supposed sexual assault, and the victim of that sexual assault is apparently the child of a former maid or housekeeper in the Jackson household, right?
Right, right.
Yes, indeed.
So
Who
what
received
is...
a monetary settlement.
Say it again?
Who received a monetary settlement.
Now, that's got to be big fodder as we return to that issue for the defense. The defense can't be certainly upset about the fact that it came in, but they've got a lot of ammunition to go after these folks.
They can't be upset. First of all, if you enter into some settlement, it's not admission of guilt. All this stuff is going to come in, and they're going to portray it as some consciousness of guilt, which is basically what the public thinks about the settlements. And that's why you have trials, and that's why you have burden of proof, and that's why juries have to make findings as to whether or not they...
It is very distressing, but the jury gets to hear about those settlements, don't they? When we return, it's great to be a comedian with your own TV show like us. No, we're not comedians, but hey, it's not like being the king of pop. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Under questioning by the defense attorney, Tom Mesereau, Ann Lopez reveals how she and her husband, George Lopez, got a lesson in star power. Here's what the jurors heard according to the courtroom transcripts.
Did you notice David's attitude towards you change after he started visiting Michael Jackson?
Oh, yes.
And what was the change all about?
Well, all of a sudden, our friendship to Gavin was not as important as them being in Neverland.
Okay.
It just seemed like a shift, that George's time and compassion for Gavin wasn't as important anymore.
Okay. And that bothered you?
Yeah.
Okay. Did you ever discuss that with David or Janet?
No.
Now, did you learn at some point after you had severed your relationship with the that Janet had met with your husband to give him a good luck charm and gratitude for all you had done?
I knew about that before. It was a little keychain.
Okay. Do you know about when that happened?
I don't remember.
Okay. Ever talk to Janet about her experiences at Neverland?
No.
Okay, but you noticed a change in attitude in Gavin and David, right?
Yes, and the other 2 children.
All of them?
All of them, yes.
They just didn't seem to be as interested in you and George anymore, right?
Well, it was just such a fantastic, over-the-top kind of experience.
And they kept talking about how much Michael had given them, correct?
Yes.
Did you get the feeling that they were sort of suggesting that maybe you didn't give them enough?
Maybe, yeah.
Good cross, Howard? No?
Good cross.
Mm-hmm.
So does it get enough mileage for the defense in this regard?
Well, I
sort of planting that seed of
It plants
now
the
they're
seed.
attracted toward somebody with more money, more notoriety, somebody who they could grift better, according to the defense theory.
that's the seeded plant, yes.
So, but does it work? Does it get there?
Don't know. Have to ask the jurors.
Okay, well, I mean, what else would you have done, though, I guess is my question.
Well, it can go on from there. I mean,
Okay.
we're looking at a segment of it, no doubt about it. But it's a good, solid segment because the seed is not subtle.
Yes.
What happens here is what Tom Mesereau is saying, hey, look, you know, you weren't giving them enough money. He had stopped with you, and now we've got the king of pop, and boy, what a mark he might be.
And you know, I represented Tupac Shakur, who was a notorious figure. He was known for being a bad guy, and he also had a lot of money. And I defended him in so many cases, both civil and criminal, for people who just saw him as a mark, who knew he had a lot of money and a bad reputation, and he was the perfect person to go after for that reason.
Yeah.
And Michael Jackson, in a similar way, is a good target.
But doesn't that's not lost on the jury, though, is it? I mean,
I
they
would think not.
understand in this day and age that people who have money are gone after, even though the claims may not be
Except
meritorious,
in a
as it
case
were.
where you're dealing with child molestation. That's the problem.
Well, it's a big major stretch.
Right.
It's one
But
thing to
he's
say
a
you're
good
trying to
mark
get
for
money.
that, in the sense that Tupac was a good mark for being a violent guy.
Right.
Michael Jackson is a good mark for being a child molester.
Which is
and
exactly
he's got money.
where the defense has to go with, now that they're stuck and buried by all of these prior accusations, where the defense goes is to say, of course, they knew all about it, so we're going to get the money.
We're going to have to leave it right there, but it won't stop. We're going to keep this going after we sign off. Our exclusive Michael Jackson trial coverage continues tomorrow, 9 p.m. right here on E! And for a sneak peek at tomorrow's reenactments, go to eonline.com tomorrow at noon, folks.